In this alternate history, one federal judge's ruling turns a redundant investigation into the end of certified elections in America.
This story is fictional. It's based on real events, but everything beyond the known facts is speculation. Our goal is to explore an alternate timeline, not to rewrite history, but to imagine what might have been.
What if the FBI's Georgia election investigation triggered a constitutional crisis? In the summer of 2026, the FBI did something with no modern precedent. It directed hundreds of analysts, not a task force, not a small team, but hundreds of federal personnel, toward a re-examination of Georgia's 2020 presidential election results. The move shocked election officials and legal scholars alike. Georgia's votes had already been counted 3 times, one of them entirely by hand. Every count produced the same result. Joe Biden had won the state. No disputed math, no missing ballots. The process had worked exactly as designed. And yet here was the full weight of the federal government's investigative apparatus arriving at the scene 6 years later. Badges out. The stated justification was vague. Potential irregularities in data handling, a whistleblower whose identity was never made public, a statutory framework that gave the Bureau just enough room to claim jurisdiction. Critics called it political. Supporters called it necessary. The country split along the lines it had been splitting along for years, and most observers assumed the investigation would produce nothing, file quietly, and be forgotten within a news cycle. But what if it hadn't gone quiet? What if a federal district judge appointed 18 months earlier during a wave of ideologically aligned confirmations put a preliminary injunction declaring that Georgia's certified 2020 results could not be used as legal precedent in any ongoing electoral disputes pending the FBI's findings? What if that ruling, narrow and procedurally technical on its face, became the match that lit everything else? The injunction lands on a Tuesday morning. By noon, it is the only thing anyone in Washington is talking about. Georgia's Secretary of State immediately calls it unconstitutional and pledges to appeal. The state's Attorney General files an emergency motion within hours. But the injunction holds through the first weekend. That holding period is all it takes. Within 72 hours, federal judges in Arizona and Wisconsin, watching the Georgia ruling go unchallenged at the appellate level, begin fielding similar petitions. The logic is straightforward and devastating. If one state's certified results can be placed in procedural limbo, why not others? The appeals courts fracture. The 11th Circuit issues a stay of the injunction on day 9, but the Justice Department contests it immediately, arguing independent jurisdiction. For the first time in American history, the executive branch and a federal appeals court are in active legal conflict over a completed presidential election. The Supreme Court agrees to hear the case on an emergency basis. The country holds its breath. The court's deliberation takes 3 weeks. During that time, 3 more states receive FBI subpoenas for their 2020 election records. State election boards in 2 of those states, facing genuine uncertainty about what compliance might mean for their own certifications, announce a temporary suspension of certification proceedings for upcoming local and federal elections. Their lawyers argue they cannot certify new results until the legal status of their 2020 records is resolved. Local races hang in limbo. Congressional seats go vacant. The House of Representatives, already operating with a razor-thin majority, drops below quorum threshold on critical votes. The Supreme Court rules 5-4. The majority opinion is narrow and deliberately avoids the core constitutional question, vacating the injunction on procedural grounds without ruling on whether federal law enforcement can challenge certified state results. The dissent runs 29 pages and calls the majority opinion an abdication. The injunction is gone, but the FBI investigation continues. The subpoenas remain active. The suspended certifications in other states are not automatically resolved. The court has handed back a grenade with the pin still missing. Congress attempts emergency legislation clarifying the legal firewall between federal investigations and state-certified election results. The bill dies in the Senate on a procedural vote. 3 senators expected to support it flip at the last moment, citing pressure from their state party organizations. The bill's sponsor goes on television and says the words that will be replayed for years afterward. We no longer have a mechanism to protect the outcome of our own elections. By winter, 4 states have adopted emergency statutes, declaring their election processes immune from federal investigative subpoena, laws that will face years of their own legal challenge. The FBI's investigation has produced no criminal charges. It has produced something worse, a template. Any future administration with a cooperative Justice Department and a friendly district judge now has a model for placing any state's election results in procedural doubt. The action doesn't need to succeed legally. It only needs to last long enough to generate uncertainty. And uncertainty, it turns out, is sufficient. The 2026 midterm results in 5 contested districts are never formally certified before the new Congress is seated. Congressional leadership makes a unilateral determination about which results to recognize, citing historical precedent from the 1870s. The opposing party declares the new Congress illegitimate and begins organizing a parallel legislative structure. 2 governments claim authority over the same building. Neither can make the other stop.
In this world, history went one way. But here, we ask what could have happened. If you want more alternate timelines and government what-ifs, subscribe, comment your theory, and stay tuned. This is State of What If.